Imagine you're facing a challenging legal issue, maybe a personal injury claim after an accident, or some complex dispute that really needs professional legal help. But the mere thought of those upfront legal fees, well, it can feel incredibly overwhelming, Ken. It's a huge barrier for so many people just trying to get justice. Or maybe you're looking for a lawyer who's, truly invested in the outcome of your case, someone whose success is tied directly to yours, not just the hours they clock up. Well, today we're taking a deep dive into a pretty powerful piece of legislation that addresses exactly these kinds of concerns. South Africa's Contingency Fees Act of 1997. Our mission with this deep dive is simple. Cut through the legal jargon, give you a crystal clear understanding of this act, whether you're just curious trying to figure out how legal fees work, or maybe you're a law student wanting to grasp its practical side. We think this will be useful. We'll be pulling insights directly from the official act itself, making sure you get the most important nuggets of knowledge without wading through dense legal text.
Yeah, and it's a really fascinating piece of legislation, actually. It shows how legal frameworks can adapt, evolve to make justice feel a bit more accessible. Historically, certain fee arrangements were, well, problematic under common law. They were sometimes seen as interfering with the purity of justice, oddly enough. But this act creates a regulated, transparent bridge. It connects that traditional legal world where you often pay by the hour, win or lose, with a more, let's say, results-oriented approach to fees. And it has some very specific rules built in to ensure fairness, protecting both the client and the lawyer involved.
Okay, let's unpack this then. At its core, what exactly is the Contingency Fees Act 66 of 1997 all about? What's its fundamental job? How does it change things?
Well, at its heart, the Act states its purpose pretty clearly. It aims to provide for contingency fees agreements between legal practitioners and their clients, and to provide for matters connected therewith. Essentially, what this means is it legalizes, and this is critical, regulates specific types of agreements where a lawyer's fee depends on the success of the case. So your payment to the lawyer is directly linked to whether you, the client, actually achieve a positive outcome. It's not just a fee structure, it's really about aligning interests.
Right, aligning interests.
And what's really fascinating here, and quite a powerful statement legally, is how the act begins. It says, notwithstanding anything to the contrary in any law or the common law. Now, that clause is incredibly significant. For centuries, legal systems, including South Africa's, viewed practices like champerty and maintenance as unlawful.
Champerty and maintenance. Can you quickly remind us what those are?
Sure. Briefly, champerty involved a third party funding someone's lawsuit in exchange for a share of whatever they won. Maintenance was similar, maybe without the direct profit motive, but still seen as improperly interfering. They were viewed as potentially encouraging frivolous lawsuits or messing with the course of justice. So by starting with notwithstanding, this act signals a very deliberate statutory override of those old common law rules. It introduces a specific regulated framework for agreements that, frankly, might not have been allowed or clearly defined before 1997. It carves out a legitimate space for this modern approach.
Wow, okay, that's a strong opening statement, essentially saying, forget the old rules on this, here's the new way. So to really get this act and how it works day to day, we need to get clear on some core terms it uses. Legal language can be a bit tricky, so let's break it down.
Absolutely. Let's start with legal practitioner. That's pretty straightforward. It just means an attorney or an advocate, any lawyer you might engage.
Okay, attorney or advocate, got it.
Then there's normal fees. These are defined as the reasonable fees a practitioner would charge if there wasn't a contingency agreement. It's usually assessed on what's called an attorney and own client basis. Put simply, it's their standard rate, hourly or fixed, that's considered fair for their services.
So not some special discounted rate, but their actual full fee.
Exactly. It's distinct from, say, party and party costs, which are the often lower scale-based costs that the losing side might be ordered to pay the winner. Normal fees means the full whack, basically. The Act also defines proceedings pretty broadly. It covers matters in court, before tribunals, even things like applying for licenses, professional services, and arbitration. But, and this is important, it specifically excludes criminal proceedings and family law matters.
Right, so it carves out a very specific area. Why those exclusions? Criminal and family law. Is it about the sensitivity or maybe what counts as a win?
That's an excellent point, and yes, the exclusion is quite deliberate and logical. In criminal cases, the main goal isn't usually money, it's about liberty, right? Tying a lawyer's fee to getting someone acquitted could create some perverse incentives or raise serious ethical questions.
Yeah, I could see that.
And similarly, in family law, think divorce, child custody, The focus should be on the best interests of the people involved, often finding fair solutions, not necessarily a quantifiable win where a lawyer takes a cut. These areas often need a more nuanced approach that just doesn't fit neatly with a success fee model. That's why the Act targets specific civil and commercial type matters, leaving those sensitive areas out.
Okay, that makes sense. It's about applying it where it fits best.
Precisely. Now, moving on to how these agreements actually work in practice. The Act outlines two main types of contingency fees agreements a lawyer can make with a client, but there's a condition. The lawyer must believe there are reasonable prospects of the client being successful.
Ah, reasonable prospect. But they can't just take any wild gamble.
Exactly. This clause is vital. It means lawyers need a genuine, objective belief that the case has a decent chance. It's meant to stop lawyers taking on totally frivolous or hopeless cases just on the off chance.
Okay, so what's the first type of agreement?
The first type, found in Section 2(1)(a), is what most people think of as no-win, no-fee. It's quite simple. The legal practitioner gets zero fees for their work on the case unless the client is successful to the extent agreed upon in the agreement.
So if you lose, you don't pay the lawyer's fees for their time. Clear risk reduction for the client.
Exactly. It massively reduces the financial gamble for someone bringing a claim.
Now the second type.
The second type in Section 2(1)(b) is a bit different. It allows the practitioner to charge fees that are equal to, or importantly, higher than their normal fees if the client is successful. This higher fee is specifically called a success fee.
A success fee, okay.
This is where the incentive for the lawyer to really push for a great result becomes even stronger because their own compensation goes up if they deliver significant value for the client.
Right, it sounds like a good way to align those incentives. But it does raise a big question. If the client wins big, can the lawyer just charge whatever they want for this success fee? Are there limits?
That's a fundamental question, and thankfully, yes, the Act sets very clear boundaries. Section 2(2) deals with this directly. Any success fee cannot be more than the lawyer's normal fees plus 100% of those normal fees. So, effectively, the total fee can be up to double the normal fee, but no more.
Double the normal fee is the first cap. Okay.
But wait, there's another crucial cap specifically for claims sounding in money. That just means cases where the main goal is a financial payout, like damages for an injury or getting back a debt.
As opposed to, say, trying to stop someone doing something.
Exactly. In those money claims, the total success fee payable by the client cannot be more than 25% of the total amount awarded or obtained by the client.
25% of the winnings.
Yes, and importantly, that 25% calculation specifically excludes any legal costs the other side might be ordered to pay you. So it's 25% of the actual award or settlement amount itself.
Okay, so there's a double safety net. The fee can't be more than double the normal rate, A&D for money claims. It also can't exceed 25% of the client's actual take, minus costs.
Precisely. It's a sophisticated balancing act. The 100% cap allows lawyers a significant upside for taking the risk, especially on complex cases. But the 25% cap on money claims, critically excluding costs, ensures that even if someone wins a huge amount, say millions, the client's actual take-home portion stays substantial.
So it stops situations where the client wins, but feels like almost all of it went to the lawyer.
Exactly. It fosters trust and ensures the Act genuinely helps the client's recovery, not just the lawyer's fees.
That seems well thought out. Now, the Act is also apparently very careful about protecting the client when it comes to the agreement itself, right? Section 3.
Oh, absolutely meticulous. Section 3 dictates the form and content of contingency fees agreement. This isn't some casual handshake deal. It's a formal, structured process. It's all about transparency and informed consent.
So what does that involve?
First off, the agreement must be in writing. And not just any writing, it has to be in a specific form prescribed by the Minister of Justice. This form gets published in the Government Gazette and even has to be tabled in Parliament. That shows how serious the regulation is, public interest involved.
Tabled in Parliament. Wow, okay.
And it absolutely must be signed. Signed by the client or their representative if it's the company, and signed by the attorney. And if an advocate is also briefed on the case, they have to countersign it too, making them a direct party to the fee agreement. Ensures everyone's accountable.
Makes sense. What information has to be in this written agreement?
It needs to spell out several key things, really to make sure the client knows exactly what they're signing up for. Think of it like a pre-flight checklist for their legal journey.
Okay, look what.
It must state the specific proceedings the agreement covers. It needs confirmation that the client was told about other ways to fund the case, like legal aid or insurance. Confirmation they understand they might have to pay the other side's legal costs if they lose.
Yeah.
That's a crucial one people sometimes forget.
Right, because no win, no fee only covers your own lawyer's fees, not the opponent's if you lose.
Precisely. It also needs confirmation the client knows they'll pay the success fee if they win, and that they understand the whole agreement's meaning and purpose. Plus, it has to clearly define what counts as success for that specific case, when fees become payable, what happens if there's partial success, or if the agreement ends early, how the fees are calculated step by step, and how disbursements, those out-of-pocket costs like court fees or expert reports, will be handled. It really aims for total clarity.
That's a very comprehensive list. Puts the onus on the lawyer to make sure the client gets it. But what if, after signing, the client gets cold feet? Is there an out?
There is. The Act anticipates that. It provides a vital cooling-off period. Section 3.3 gives the client 14 days, starting from the date they sign, to withdraw from the agreement.
14 days. How do they do that?
Simply by giving written notice to the legal practitioner. It's like a consumer protection safeguard, really. Gives you time to think it over, maybe even get a second opinion.
Can you just walk away clean then?
Well, mostly. If the lawyer has already done some necessary or essential work to protect the interests of the client during those 14 days, maybe filed something urgent, they are still entitled to be paid for that specific work and any related disbursements. But that work is charged at their normal attorney and client rate, not the success fee. So it protects the lawyer from doing urgent work for nothing, but still gives the client the right to change their mind about the contingency part.
And they get a copy straight away.
Yes, absolutely. A copy of the signed agreement must be given to the client on the very day it's signed, so they have it immediately to review during that cooling off period.
Okay, that sounds fair. Now, what about settlements? That's often where cases end. How does the Act handle settlement offers?
Section 4 details a very specific, quite rigorous process for settlements. It's designed to ensure the client's interests are absolutely paramount and they aren't pressured into a bad deal.
How does it work?
The lawyer can only accept a settlement offer after filing a detailed affidavit. If the case is already in court, the affidavit goes to the court. If not, it goes to their professional body, like the Legal Practice Council.
An affidavit. What does the lawyer have to swear to in this affidavit?
Quite a lot, actually. They need to outline the full terms of the settlement offer. They have to give an estimate of what they think the client might get if the case went all the way to trial. They need to assess the chances of winning or losing at trial. They have to compare their estimated fees if the case settles versus if it goes to trial. They must state the reasons why they're recommending the settlement. And crucially, they have to confirm they explained all of this to the client and what steps they took to make sure the client understood it all. And finally, confirm the client told them they understood and accepted the terms. It really forces a thorough consideration and documentation of the advice given.
That sounds like it puts the client firmly in the driving seat for settlement decisions.
It does, but the layers of protection don't actually stop there. The lawyer's affidavit isn't enough on its own. It must be accompanied by a separate affidavit from the client themselves.
The client have to file an affidavit too.
Yes. In their affidavit, the client must state they were notified in writing of the settlement terms, that the terms were explained to them, that they understand and agree to those terms, and they have to express their own attitude towards the settlement.
Wow. That dual affidavit system seems pretty watertight. Makes it very hard for anyone to claim later they didn't understand or agree.
Exactly. It adds a significant, undeniable layer of client consent and protection. And if the case was already in court, the settlement must then be made an order of court, adding a final layer of judicial oversight to confirm its fairness and make it legally enforceable.
That's a very thorough process for settlements. But let's say, even with all these rules about the agreement and settlements, a client still feels something's not right. Maybe they think the agreement was unfair or the final fees charged were unreasonable. Is there any way to challenge it after the fact?
Yes, indeed there is. Section 5 provides a crucial avenue for exactly that kind of situation. It's a review mechanism. A client who feels aggrieved can refer the contingency fees agreement itself, or the fees charged under it, to their professional controlling body.
So back to the Legal Practice Council, for example.
Precisely. Or another body, if the Minister of Justice designates one for this purpose. And this body has real teeth. It has the power to review the agreement or the fees and can actually set aside any provision or the fees themselves if it finds them to be unreasonable or unjust.
So they can effectively rewrite parts of the deal or reduce the bill if it's deemed unfair.
That's right. It offers a vital way for clients to challenge arrangements they believe are unfair, even after everything's signed and sealed. It provides a powerful layer of ongoing oversight and a backstop against potential abuse. It really speaks to the Act's commitment to fairness.
It seems the Act isn't just a set of rules put in place in 1997 and then left alone.
Not at all. Sections 6 and 7 are designed to ensure ongoing oversight and adaptability. The professional controlling bodies, or the Rules Board for Courts of Law, can actually make specific rules to help implement the Act effectively. And beyond that, the Minister of Justice can make further regulations for implementation and monitoring. So the framework isn't static. It can be refined and adjusted over time to meet new challenges or address any unforeseen issues. It's meant to be dynamic.
Okay, so it's designed to be a living framework. Let's pull back then and connect this to the bigger picture. What's the real-world significance, the main impact of the Contingency Fees Act, especially for ordinary people needing legal help, and maybe for the lawyers of the future?
Well, its significance is profound, primarily for access to justice. That's really the cornerstone. It directly tackles that huge financial barrier that stops so many people from pursuing legitimate legal claims. By allowing no win, no fee, or success-based fees, the upfront financial risk for the client is drastically reduced.
It opens the door for people who just wouldn't have the cash otherwise.
Exactly. Think about someone seriously injured in an accident, maybe unable to work, facing huge medical bills with no savings. Before this act, pursuing a claim might have been impossible. Now, there's a viable pathway for them to seek compensation. And it also, as we discussed, powerfully aligns the lawyer's financial interests with the client's success. This can encourage a more dedicated, efficient effort to get the best possible outcome.
Because the lawyer only gets paid well if the client does well.
Right. They're motivated by the result, not just by billing hours. For law students, understanding this act is just fundamental now. It's a key part of modern legal practice and fee structures. It shows how law can innovate to meet society's needs. But, it's not without ongoing discussion. Does it perhaps subtly encourage lawyers to only cherry-pick the easy win cases, potentially leaving people with complex but still valid cases struggling to find someone willing to take the risk?
That's a fair question.
Or does the administrative burden, like those affidavits for settlement, add too much complexity? These are points people debate. But overall, it strikes a crucial balance. It aims to ensure lawyers are fairly compensated for their expertise and the risk they take, while making sure money isn't a complete blocker for ordinary citizens trying to access the courts.
We've certainly taken a deep dive today, really exploring the Contingency Fees Act of 1997. We've looked at its core purpose, boosting access to justice, its historical context, overriding old rules, all the way through to the detailed protections for clients, the settlement procedures, the review mechanisms, and its overall significance in South Africa today. It's clearly a very comprehensive law.
It really is a foundational piece of legislation. It continues to shape how legal services are accessed and paid for, and it strongly emphasizes transparency and fairness in these agreements. It's a great example of how law can evolve while trying to maintain crucial ethical standards for the profession.
So the next time you hear about a no-win, no-fee deal, or a lawyer taking a case on contingency, you'll know there's this robust legal framework behind it, designed to carefully balance the risks and rewards for everyone involved. And maybe something for you to think about further. How might this act, with all its detailed rules and protections, influence the types of cases lawyers are actually willing to take on? Does it truly level the playing field for everyone seeking justice, or are there still gaps and challenges in making legal help fully accessible to all?